Oh, hey folks, elder law care attorney Patrick Kelleher coming to you from elderlawcare.com. Folks, great question today, very important question regarding disability planning for an incapacitated person or a person with special needs, okay? Really important to know the rules of engagement around that. And the question specifically from today's subscriber is like, hey Patrick, how can an ABLE account assist our disabled family member? An ABLE account. ABLE account is a fairly newer law, came out maybe less than 10 years ago or so. And the government likes to use acronyms. ABLE, A-B-L-E, stands for Achieving a Better Life Experience. Achieving a Better Life Experience. And it is a new law that allows family members to create a savings type investment account where dollars can be deposited into this ABLE account under Internal Revenue Code 529. And the monies in there can grow tax free. And the monies in there can be dispersed and distributed to your special needs loved one for what they call qualified beneficial expenses or qualified beneficiary expenses. And that's really important to know, folks. Once you deposited money in there, the nice thing about it, it can grow tax deferred, and then disbursements of the money to your special needs loved one are income tax free, which is wonderful, right? So long as it is for what they call QBE. They could be things like housing, education, transportation, health, wellness, employment training, okay, and health and well-being, things of that nature. However, if the money's been used for things that do not fall under the category of qualified beneficiary expenses, if they're non-qualified beneficiary expenses and they're being dispersed, that's not so good because then the beneficiary would technically have to pay taxes on the income they're receiving, and in addition, pay a 10% penalty. So you really need to get your head around that. You need to print out a list of the qualified beneficial expenses and stick to that. And do not make any disbursements for anything that does not fall into that category that I just read off, okay? The other disadvantage to it would be it's subject to Medicaid payback, meaning that if there's any funds left over in that ABLE account when your loved one passes away, it has to go back to Medicaid right there. And Medicaid and the Social Security Department or the Social Security Administration, they monitor these ABLE accounts for what type of disbursements are being made and so forth. So it's non-countable for Social Security, SSI, supplemental security income. So if your loved one, your disabled loved one with special needs is also receiving from Social Security, SSI, supplemental security income, which is a means tested public benefit, meaning they cannot have more than $2,000 in their name for assets, the ABLE account is okay because it's exempt. If you have 100 grand or less in the ABLE account, it's not going to disqualify them from their SSI. But wait a minute. Under current law, the ABLE account, if it goes over 100 grand, it's going to pause. It's going to pause their SSI benefits. It's not going to take it away from them, but it's going to shut that faucet off, and they're not going to turn the faucet back on until you get back under that $100,000 threshold. The other important thing to know about this law, in order to qualify for an ABLE account, the individual who's receiving the benefits or the beneficiary of the ABLE account, it's required under current law that their disability had to occur before age 26. Before age 26, right? But good news, folks. Next January 1st, 2026, the law's supposed to update from age 26 to age 46, which appears to be a lot more reasonable. And lastly, I mentioned that I was going to share with you a stronger recommendation that I have for you. ABLE account, from my experience, can be a good supplemental tool to use to protect and preserve some funds for your special needs loved one. But from my experience, the bigger, stronger protection you need to create for your special needs loved one is what they call a third-party supplemental needs trust. And you can either create a standalone third-party supplemental needs trust, or when you're creating your trust center plan with your elder law attorney, Bill and Mary's Revocable trust will say you create a subtrust, a third-party supplemental needs subtrust for your special needs loved one. Step two is trust funding, getting your treasures into the treasure chest. Because when you get hit by the bus of life, you need to make sure that the money's not going directly in the hands of that special needs child, because that will be catastrophic. That will knock them off their government benefits, and then they'll have to do a spend down, and all that inheritance could be gone for naught back to the government. So the treasures need to go into the treasure chest. The life insurance, the retirement accounts, the house perhaps, the bank accounts, whatever it may be, or all of the above, goes not directly to your special needs child, but it goes to the trustee of your special needs child's third-party supplemental needs trust. There you have it right there, folks. Now they can continue to receive their means-tested government benefits for their needs-based care, and the extra money protected in their third-party supplemental needs trust can be used for their extras. And the beautiful thing about the third-party supplemental needs trust, folks, does not require government payback. So you can name your other children and loved ones as backup beneficiaries there. Folks, be sure to click the subscribe and notification buttons, pick up copies of my books on Amazon, and continue to become that informed consumer. Hopefully you found this educational video helpful. Post a comment, a question, let us know what you thought, and let us know if you have any additional questions regarding your loved one's special needs as well. Folks, thanks for joining us today at elderlawcare.com. God bless. Elder Law Attorney Patrick Kelleher.